What's up, gentlemen? This is Rising Phoenix Podcast, the podcast about how to rise up after your divorce. I'm your host, Michael Rhodes. Let's get into it. Joining me today is Joseph. Joseph, let's just dive right in. Why don't you tell us a little bit about yourself and what you do?
Yes. Hello, everyone. My name is Joseph Willmore. I am a divorce and family law attorney in Southern California. I am primarily based in San Diego, but I do service clients throughout the state. I'm a certified family law specialist, and I have been doing this for 10 years.
Okay, great. And thanks for coming on, first of all. As guys going through divorce, obviously legalities are a huge part of it. And sometimes it's hard to see through rumors and myths and legends and biases and things of that nature. And so I want to kind of hone in on some of those things and talk real talk about someone who's been through this process. And from my understanding, there isn't a more difficult state to go through marriage or go through divorce in than California. Again, rumors and things of that nature.
And I'm going to touch on that is that it's absolutely true. No state will make things more difficult for you in pretty much any regard than California. And that absolutely goes into play with divorce.
I'm sure.
Well known to be the state with the longest process for divorces and the most complicated process as well.
There's a rabbit hole there, but before we get too far, so first we're gonna address custody issues and something that is talked about often. I run a support group on Facebook. There's almost 6,000 men in there, and frequently it's talked about men keep getting screwed. Like men get screwed on custody, on child support, on alimony. But let's talk about that first piece of it, custody. From what you have seen over the last 10 years. Has there been any shifts or any changes? But are men getting screwed in terms of custody in your experience?
I do not believe it is implicitly biased against dad with regard to custody. Now, how fathers frame their custody position is absolutely critical. And that needs to really be established from a very early point in the case, because judges are people too, and they do make decisions very quickly. So when it comes to custody, I always say, fathers should not sit around. Fathers should not wait around for mother to be cooperative, because in very contentious matters, oftentimes one parent will try to keep the other from the kids. But dad having an established track record of involvement with the kids, making those attempts despite objections, and most importantly, filing a custody request with the court will help show the court that dad does want involvement, dad has the availability to be involved, and that's something that should happen for, of course, the best interest of the kids.
Yeah, so it's all about taking action, right? Initially,
absolutely,
like deciding. Is there besides that, are there other things that fathers can do or should do to help their case in terms of getting to at a minimum 50-50?
So even during the marriage, and this is something, when I'm lucky enough to get to talk to guys when they're at that point where they're not filing for divorce yet, but it appears imminent, is they really need to make sure it's apparent that they are actively involved in child uprearing and child care. And that can be activities as simple as making sure you're involved in their extracurricular activities, making sure you're helping with their schoolwork, and making sure it's very clear and very apparent that you are really involved in these kids' life. Because if that's really imbalanced only with one parent doing those things, that will present custody challenges.
How hard is that to come back from? Like, is it game, set, match, or is it like, okay, she's filed, now I got to do something? Is it too late at that point, do you think, or can you still save things?
So here's what I would say is that it's never too late, but it can involve essentially step up parenting schedules. So say we have a father that's had always traveled for weeks at a time and was not around, and mom was doing all that parental responsibility. Comes divorce, dad is not traveling anymore, but the kids aren't necessarily used to being under dad's exclusive care for long periods of time. In a position like that, dad would be best framed as far as making his arguments to the court with regard to a step-up parenting schedule. Not saying I need equal time right now, but saying that I'm keeping the children's thoughts as well as what they're used to as far as stability and continuity, as far as kind of integrating more time with dad. Again, not saying that dad poses any threat of danger or is unable to be a parent, but the court's going to look at what are the kids used to and how can we get the kids used to this new normal.
Yeah, and you bring up something there about safety, and that rings a bell on my head, and it's something that I do agree that again, it's probably typically against men, but I do think is an issue, and I don't know what the answer is false allegations. I hear this quite frequently. They'll file restraining orders, things of that nature that have no basis in reality, at least according to these gentlemen. I only know one side of the story typically. So do you see a lot of that, the mother, the soon-to-be ex-wife making false allegations? And if so, what are men supposed to do in those regards? How do they handle that?
It is sadly very common for false allegations of abuse being made in family court. Some attorneys who I would refer to as, just very bad practicing attorneys that just look to dump gasoline on fire. Some of those attorneys will pretty much always tell clients, you need to file a restraining order when you file for divorce. And that does not, shockingly, things don't start off well in those cases.
Yeah.
And anytime restraining orders are filed, it's the court has to consider presumptions of domestic violence. Yeah. And parties will do that typically with regard to one of two objectives. If they are the higher earning party, they want to not pay spousal support. And if you prove that you're a victim of domestic violence, public policy says you shouldn't have to pay support to your abuser. Number two, of course, what we're talking about right now is kids, is that if you are found to have committed acts of domestic violence on your spouse, you are presumed to be a threat of harm toward your children as well. Now, last year, in California, they expanded what can be considered domestic violence. That goes from as simple of acts as disturbing the peace of the other party, which is very subjective, to forms of coercive control. Again, very subjective as well. So this is so far beyond, physical or verbal or mental abuse.
So
it's very subjective.
How the hell do you deal with that? like what is it? Let's say the allegations are man, this brings up so many things. But let's say the allegations are false. What is it after something is filed? What does a man do at that point? What are his options? And does it affect things long term if they're false and can be proven false?
If it is proven that a parent continually makes false allegations against the other parent, that can be a cause as far as them not being a responsible co-parent with regard to kids. If it's shown that they are actively taking steps to prevent the other parent from having a meaningful relationship or contact with the children, that can negatively impact their ability to have time with the children as well. A difficult thing to prove. Again, my basis of discussion is how things work in California.
Sure.
This is a very slow process, regardless of how it unfolds. But rebutting these facts can be a number of ways. So if there's forms of saying allegations of physical violence, are there actually photographs of injuries? Are there witnesses that can corroborate it? Have the police been called out to the house? If somebody claims years of enduring physical violence, yet they don't have a single witness, a single photograph, any piece of evidence that can corroborate that would in fact diminish their claim. So the burden of proof is still on the person making the allegations to prove that they actually occurred. Now, generally, at least as far as granting temporary orders, the court is generally going to err on the side of caution, saying, all right, well, if this is really going on, we're going to put a restraining order in place right now to allow that person the ability to prove that.
So have you seen examples of this, of false allegations turning out to bite people in the butt? Because I hear all the time that it doesn't, which I find hard to believe. I can't imagine that if someone keeps lying, that the courts don't take umbrage to that. Have you seen examples of such things?
I have. One case recently that kind of stands out is that it was a 30-year marriage. This was not necessarily related to children, right, but extreme allegations of physical abuse over the span of 30 years. And this was a wife making allegations against the husband for physical abuse, black eyes, other injuries that would have involved, visual, injuries, right, not a single photograph. Mentions of, again, I said coercive control. In this case, wife was alleging that husband did not allow her use to any money. Yet we had to go through, I went back 10 years on this case because that was more than sufficient. Right. But 10 years of bank statements showing that wife was writing checks on their accounts. Wife was a joint, signatory on all their accounts, had credit cards. Wife had access to everything. There was no coercive control. And then it was with regard to verbal abuse as well. Now, that's a lot of he said, she said, but text messages can prove a lot now, and they are huge pieces of evidence as far as corroborating whether somebody is verbally abusive to the other. And when I have text messages on this case of wife not being nice to husband and husband actually not even responding aggressively or hostile at all to these text messages, showed that wife was actually the aggressor. So in that case, of course, wife's restraining order was denied. The judge went so far as to call wife a liar, saying that this was a falsely, filed restraining order, clearly malicious, with other intentions aside from any act of domestic abuse.
Then here's where I could see the need to make some changes, right? If that's the case, if allegations are proved false, why is it, and I don't know how the hell you can answer this, but maybe you could, why is it that there isn't some kind of punitive damage to that person, like some kind of something? Like, if it seems to me that if you make false allegations and it's proven false, you should be charged with something. And maybe that's the answer, is there's no law against it. Why the hell not?
I believe that I absolutely concur with that. So here in California, we would have prevailing party. So if you prevail in a matter such as that, you can request your attorney fees be paid for. Okay. The issue that we run into here again is that the court would also consider that person, meaning the person who falsely filed that, their ability to pay. So even if they falsely filed something, the falsely accused prevailed, yet the one making the false allegations does not have the money to pay, the court's not going to order that they pay the other person's attorney fees. It is, I will just go so far as to say that it is a horribly broken system, and it needs, repairs on all ends, quite frankly.
Yeah, I mean, that's what I hear. I want to go back to you mentioned California being, it's pretty bad out there in terms of the system. And when we first started talking, it pinged in my head, and I wanted to ask the question at that point: why is it so broken in California specifically?
Gosh, I think that might get into a talk of politicians and general leadership. But I do think it is perhaps a top-down issue from mismanagement on on the very high levels, which of course just trickles down into every other agency throughout the state. So I just see a whole lot of issues that really need revisiting. So ultimately, the laws that are in place were decided on by the legislatures. Yeah. Obviously, I have clients that come to me all the time saying, "Well, that's unfair. You need to argue that law is wrong." Right. and that would be great, quite frankly, if I could, because oftentimes I'll agree with the client. You're absolutely right. That law is unfair. That law is wrong. Yeah. Unfortunately, your case is not going to change the law. That is up to, the people taking that up with the legislature, saying, hey, we want these laws changed, because, as attorneys and as the judge as well, the judge has to go by what the laws are. So the judge can't say, well, I don't like this law either. I'm gonna disregard it. Right. So it's really, I would say, kind of up to the people of California to say, hey, there needs to be a change in these laws, because it's producing an inefficient court system and unjust results on occasion as well.
We talked before we started recording, and forgot that we were going to talk financials first. So let's not that we won't come back to the custody thing, because I think there's probably a little bit more there to mine. But I think if we could shift into the financial aspect, speaking of child support and alimony and spousal support and all that kind of stuff. And I think specifically, if we could speak child support first, and I'll speak, I'll sort of ask this question by first giving my situation. And I know every state is different. So in Pennsylvania, it's just a formula. And that formula seems to me to be out of whack. Like, I don't know who the hell wrote the formula or devised it or whatever. But because I make more, even if I have my kids equally, I pay more and a decent amount of child support every month. I don't mind supporting my kids, don't get me wrong. But is that how it works in California? Is it strictly based on a formula, or do you have to go through a hearing and a judge looks at everything and he decides what the amount of support is? How does it work in California?
So it absolutely does go based on a formula. This can, and I will say, it does not vary tremendously by county. There's essentially one of two softwares that the courts use to it. It's essentially sounds similar to what's going on in Pennsylvania. Yeah. What they call it here is either the DissoMaster or ex-spouse. And those are essentially the calculators that come up with this magic number. Now, for spousal supports, we look at that calculation as a suggestion. So the court is not bound by the family code to follow what the DissoMaster or what ex-spouse says spousal support should be, but it's an arguing point. Right. Now, for child support, the court is bound by what it determines the calculation to be to order that. Now, for attorneys, we have the ability to argue what should be considered income, what should not be considered income. If a court-ordered parenting plan is not followed, what we argue the actual percentage of parenting time should be. But ultimately, what the court will order here, after attorneys argue what should and should not be considered, is when the court determines what dad's income is, what mom's income is, and what the percentage of parenting time is with the kids, that number will be it. So I always use the example, if the parents have equal time with the kids, so it's a 50-50 custody schedule. Dad makes $20,000 per month, mom makes $10,000 per month, dad's going to pay child support. The family code here at least states that child support is fair in that situation because the child should enjoy a similar lifestyle in both households.
That one, I have a hard time swallowing that one. In my case, I can only speak from my experience, but she made a decision, right, to leave, right, and there's so many things to this. There's no saying what she's doing with that child support, right? So who knows if it's actually if they're able to have the same kind of lifestyle in both homes, because I don't know what the fuck she's doing with that money. Like, there's no checks and balances, so to speak. But I want my kids to be taken care of, but I feel like the formula is just fucking out of whack, because even if there was some checks and balances to what she could do, why is it that, I don't know, there's so many questions to this, but like, she made a decision to leave, right? That's her decision. So her lifestyle choice is her decision, and that the kids will be affected because of that. But I have to swoop in and give my money to make sure that they're still, without any guarantees, that they're still going to have the same type of life. They aren't. They will not, regardless of money, because we're different people. But I don't. When custody gets to 50-50, I can see it when it's not 50-50, or I could see it maybe if she isn't working, but that's a whole other thing. I think, again, talking about the sort of the antiquation of the laws. She has a career, she works, she has a master's degree, and she does okay. She doesn't do as well as me, but it just seems strange to me that I should have to supplement essentially her lifestyle, right? Because the money that she would spend on them, now she's getting from me in theory, right? And I just have a, did you ever have clients that have these questions? Like, why?
Absolutely.
Why the fuck am I helping her out? Like, this is her decision. She should have consequences. So,
and I completely agree with what you're saying. And this is such a hard pill for a lot of people to swallow. I would say, I know we've talked a lot about dads making more money here, but that's changing a lot in the world too, to where this is something that becomes perhaps a hard pill for a lot of women to swallow as well, when they were the breadwinner throughout the marriage. And this becomes more evident in, of course, doing this for 10 years, certain professions where there oftentimes are females that are the higher earner, and they have a husband that is much lower earning. And of course, upon divorce, it ends up being mom paying child support to dad. And of course, we can talk about the gender roles of that all day long.
Right.
But kind of focusing in on this, we kind of would want, and perhaps this is something, again, that the public needs to take up with the legislature as far as how the result of this is actually playing in the real world. But if we have two parents in two separate households that both have enough money to provide for the children, mind you, one parent perhaps has more of that ability, it is understandable to why it would be perturbing to a lot of people out there. Why is this the result, and why is this fair? Now, here in California, there is an exception to this calculation, and it's only with regard to extreme emphasis on extreme high earners. And that really has to be, quite frankly, in the tens at minimum million, if not hundreds of million per year. So really, we look at that. Well, who's really going to fit that exception? Of course, perhaps some celebrities would. Certainly Elon Musk would, if he still was domiciled in California.
Right.
But that's really the only exception to this. So even if one spouse is substantially better off than the other, they're still probably not going to quite make that threshold of just extreme wealth to where, okay, we'll deviate from this child support formula because you're just so filthy rich, the other person doesn't need quite that much in child support.
I mean, I suppose I think we had this conversation briefly before. It's not really biased against men. It's biased against the higher earner, which typically is men, although that is changing. But are the formulas outdated or just plain wrong, do you think, in your view?
So I kind of look at it two ways. And with regard to child support, I do believe there is a margin for improvement here, because this isn't always an accurate result, quite frankly, oftentimes. Again, I think, if we were to allow judges really the ability to evaluate this on a case-by-case basis, rather than just saying, well, that's what the calculator says, so that's what I'm ordering, go on your way, get out of my courtroom. I think results will be much more equitable, and I certainly think that would change the general public's view of family court. Now, if we talk about spousal support, which is a whole nother monster in and of itself, I will say that from a public policy standpoint, of if one person did financially support the other spouse for an extended period of time, it should not be society's burden for that person to go on welfare and the rest of us have to now pick up.
Sure.
So as far as spousal support serving a rehabilitative period to allow that person to transition out of the marriage, get a job, learn job skills, and become self-sufficient, I think the general purpose of spousal support is well-intentioned. Now we can, of course, argue people that abuse it all day long, because, of course, that does happen.
Sure. And in terms of, have you ever seen it like child support? Has there ever been any cases where it was brought up and proven like she's not using this money for the children? Has that ever happened? Do people even attempt to sort of, push back on that?
So I can speak for California. Is unfortunately that is just not a factor that the court considers. We can't even really look or make that request. I mean, if we were to subpoena bank records, for example, and we were to see grocery bills or bills at department stores, as far as getting down to the nature of what exactly was bought on that grocery visit, or was that visit to the department store for your own lingerie, or was it for clothes and backpacks for the kids? We're just not able to get quite to that level.
Yeah, I think it'd be a resource issue, right? Like, how the hell would they be able to do that?
And I know, again, I speak from California, judges really don't like micromanaging to that degree or even getting to that level of intricacy. Now, one of the big things and a big arguing point with regard to child support is whether a parent is actually earning up to their earning ability. So, say during the marriage, if one party was, employed as a CPA, and they get divorced afterwards, that person decides, well, I don't want to be a CPA making $150,000 a year. I think I'm just going to go be a bookkeeper, and make $50,000 a year. And then, of course, they want child support after that because their income is less. That is not a valid claim for child support under those circumstances because they do have a demonstrable earning ability. So can the court force them to go back and be a CPA? No. But will the court look at that as their earning ability and say, okay, well, when we calculate child support, we're going to base it on your income at $150,000 a year, not $50,000 a year.
Do you see? Because that's something I see all the time too. Is like, she quit her job, and or maybe she'll quit her job, or all these sort of like maybes. Have you seen people do that and then sort of reap the negative consequence from that?
Absolutely. One thing that will happen on occasion is when a spouse, or rather when one person's ex-spouse remarries somebody else, they might try to decrease their earning ability and then claim child support in that situation. And in those situations, again, we look to what their earning ability is. And the courts, quite frankly, don't want to see people play games like that as well. So I would say the court generally is quite strict and quite firm on what a person's actual earning ability are. I would say, as a general statement, again, the public shouldn't be too concerned about that, because if they do have a demonstrable earning ability and they voluntarily choose to reduce it, they're not going to get rewarded for that.
So isn't a lot of this about having to, I don't know if classifying it in this way is correct, but isn't it about playing the game? Like, you can't go into this without a lawyer. You can't go into this without trying to protect yourself and being mindful of the things that could occur. Like, if you just like, well, whatever, I'll sign it and we're divorced, and then next thing you know, she quits her job and you're paying child support and you don't take it up with the courts. Like, don't you have to be sort of be active and certain circumstances, if it's an easy divorce and no kids and all that, but don't you really sort of have to pay attention to be active and make sure that you're paying attention?
Absolutely. And even following a divorce, if there are kids involved and support involved, both parents owe an ongoing duty of disclosure with regard to their income to the other parent until all their children are 18 years old. That's that's a hard pill for a lot of people to swallow. And if you have a very vindictive ex, you might be back in court a lot. Again, here in California, technically you can file modifications on a lot of these issues at any time. Generally, you do have to have a reason. But of course, when you go to the business office at the court and file something, they're not going to really, they're clerks. They're not going to inquire as to your reason. So the other party is still going to be, hailed back into court, having to file responsive pleadings, potentially having to go get custody evaluations done, disclose financial information. If one party's hiding the ball, maybe issuing subpoenas. If you have somebody who's very vindictive on the other side, you unfortunately might be back in court a lot, even after your divorce is done.
Ugh, that sounds like a nightmare. I was trying to think in terms of protection and things that men can do. We talked about being active as a father, right? That can be a thing. And then obviously, like we just said about having a lawyer, that's absolutely necessary. So in that sort of regard, as a lawyer, what do you recommend men look for when they're lawyer shopping, so to speak? Like what are some of the things that you would say to maybe yourself? Like what would be some of the things you would look for if you were going through this in an attorney?
I think one of the most overlooked things is the personality of your lawyer. And this boggles my mind, how many people hire these attorneys that just don't have the ability of communication, but they hire them. Oh, you've done this for 30 years, you're old, you must know something. Right. And these old guys go into court, these old attorneys, and literally walk in there and say, Your Honor, do whatever you think you should do. Don't even argue anything. And if your lawyer isn't, telling you what should happen, what that judge should do, and why they should do it, fire them on the spot. Oh my God. Yeah. And when you first meet with an attorney, again, obviously you're not going to see their courtroom performance, but ask that attorney, what would you do? What do you think of these facts? And what are my likely results here? And if you like everything your attorney says, there's a good chance you need to run away, because that attorney is probably lying to you. There is not a single case that does not have a weak point in it. And that's not saying that you're just going to bend over and take it on that issue, but you have strategy. Okay, well, these are some bad facts in your case, but here's kind of how we would want to work around that. Everybody should want an attorney that knows other attorneys in the community as well. Chances are, whoever your ex hires, you'd want your attorney to have worked with them before, because obviously, if your attorney has a good working relationship with a number of other attorneys, they probably can solve a lot of issues in your case. Ultimately, if your attorney does not make meaningful attempts at settling it, they're doing a tremendous disservice to the clients as well. Trial and litigating a divorce is really only necessary when the other side is being just so unreasonable, you have no choice but to.
Is that the last resort, going to trial, or do you feel like sometimes you have to, because you're, and maybe this is different for men and women, but if you're representing a man and there's all these biases and things, perhaps, like, do you find that going to trial is more effective, or do you always try to avoid trial no matter what?
Well, the court in California is always going to require us to at least attend what we call a mandatory settlement conference here prior to the court even being willing to set trial in a divorce. So that really is our, last good faith attempt at trying to resolve all the issues. Some issues in a community property state like California, quite frankly, should not be litigated. So, for example, if a retirement plan was, they could even have some partial separate property interest, easy to calculate, but we can always calculate what the community property interest in some assets are. Right. And, litigating an issue like saying, oh, well, I don't want her to have any of that, even though community property law says unequivocally and without a doubt she gets X percentage of it, you're wasting your money litigating that issue. But now if we're arguing issues of, say, a person's earning ability, breach of fiduciary duty, which actually comes up a lot. So if a person expended a bunch of money on non-marital assets without the other person's permission, or, asset waste, meaning they just completely lost it or just did something really stupid, not in the best interest of the marital estate, that's an issue that can be litigated. Children, those are hotly litigated issues as well. Again, if there's really no middle ground, those are probably issues that need to be litigated.
Yeah, I think around here it's the same kind of way, where there's so many levels, like conciliation, mediation, like they really try to avoid trial altogether. When you get to trial, do you find judges that are sort of, you mentioned older lawyers who are sort of maybe stuck in their ways is a good description. Do you find that same sort of thing with judges, or are there some judges that are just old school and they're not sort of seeing anything other than the way that things used to be?
Actually, I would say a lot of judges are, again, in California, they're very open-minded. There's a wide age variance between judges as well, to where we'll have judges in their 40s, some judges in their 60s, just such a wide degree of spectrum that these judges fall on. Now, of course, being before a lot of these judges enough times, you can certainly learn certain implicit biases that one judge may have versus another. But then that kind of puts it on me to make sure that I tailor how I present this case to make sure, well, keeping in mind that this judge generally, for example, if I know this judge generally orders very low support and expects everybody to be able to find a job making a lot of money the next day, and I'm representing a individual who has not worked in 20 years and probably has a minimum wage earning ability, I got to keep what I know about that judge well into mind.
Yeah, well, I'm sure that those things are something you probably pick up, over the years. Is there a lot of turn? I guess there probably isn't, but I'm not sure, honestly, how it works here. I know it's all elections, I think. Is there a lot of turnover in family law judges, or are they pretty much, you get for a period of time, you have the same judges?
And this is a horrible way of how it works. Usually family court here gets the brand new judges. So on top of the fact that, a lot of times these judges don't even know much about family law, they're often very excited to get out of family court, just pay their dues there and get out. So these generally aren't seasoned judges that know much about family law either, or even really care to learn a lot about it.
Wow. I'm guessing that's part of the problem, right?
Definitely another layer of issues that go on to it.
I want to ask you something a bit selfish, and I promise you, when I say it's for a friend, it really isn't me. My custody is set, but I have a friend who has a daughter. She's, we'll say, between 8 and 10, somewhere in there. I don't want to, if anyone's listening that might be able to pick up on it, but he had 50-50 custody for a long time, for like 6 years. And then for whatever reason, his ex decided that she wanted more custody. And she went back she filed, and I think they went through all the various steps, but they eventually made it to a trial. And he had a psychologist evaluate the situation. And he says because of that evaluation, he lost custody. He went down to 20%. I don't know what that psychologist said. I don't know the ins and outs of this, but at face value, that's what happened. How would you recommend he fight it back against that and get more custody time back? What's the strategy there?
I would be kind of interested to know what exactly that report said in it, as far as, because that report must have made some recommendation that dad could not care for that child. So I believe there had to have been, and I'm basing this on how it would have occurred in my mind here.
Sure.
Is if he had years and years, you had said 6 years of equal time, the courts really look at what is in the best interest of the child. If that child is used to having frequent and regular contact with both parents, is this a parenting plan that has served the stability and continuity of the child? Is this child doing well under this parenting schedule? So I would be inclined to believe there had to have been some pretty damning statements made in that report against the father. So that could have been, and what this very well may have even boiled down to is, was dad available for the child? So I used the example previously, if dad is traveling for extended periods of time and the child is in the care of a third party, right, even if it was, say, the paternal grandmother, the court's still going to say, well, if dad's not around, the child should always at least be with one of the parents.
Right.
And in that situation, they might have said, well, mom should have more time if dad doesn't. Any factor aside from that, it must have, the only thing I could see in that situation is some allegation of neglect, and give, how old was the child again?
She's, I'd say around 8, 9, 10, somewhere around there.
8, 9, or 10. I mean, that's still a little bit on the young side to even ask the child their preference as far as where they wanted to live. Yeah. Typically, that does not happen until they're typically 13 years old or greater. Yeah. So sounds like there's a lot of facts that might be unknown, but that report probably might give us some inclination as far as why.
Is it possible that the report was biased? Perhaps the other attorney and the ex-spouse hired that person. I'm not saying it was nefarious or whatever in terms of like, here's some money and write a bad report, but maybe they were hired by them to sort of on that side of things. Have you seen, psychologists, they're sort of, regulated and licensed and all these things. So I can't imagine that they would do something like that. But have you ever seen that where it was just a false or inaccurate, perhaps is a better description, report. And then you could write that ship, so to speak, if you then yourself hire one or ask the court to appoint one. Is it, I guess what I'm saying is, have you ever seen a less than honest report from a psychologist or a child psychologist or whatever? And if so, were you able to, and are you able to sort of push back on that and get your own report, so to speak?
And absolutely. So this could have panned out a number of ways. Certain courts, such as here in San Diego particularly, send parents to what's called family court services. And essentially what that is, the social worker tries to get them to mediate, and I say that in parentheses. But ultimately that social worker will write a recommendation to the court as far as what they believe custody should be if the parents don't agree on something. Now, we could get into evidentiary rules on why that isn't hearsay all day long, because it is, but it's admissible. So in a situation like this, so say they were in San Diego, they had an FCS report, and dad was just beat up in that report. It's kind of up to dad at that point to where, okay, well, I want to request a trial on this issue, meaning it's not just heard as a short hearing. Dad gets the ability to present comprehensive evidence. Dad can subpoena that social worker to come in to testify. Dad can hire his own experts to evaluate the situation and write an additional recommendation. Any statements made by somebody else, you can always bring in witnesses to help corroborate your position. So I feel that I need a lot more information.
Sure. Yeah.
to know the specifics of that, but there is such a wide amount of information you can bring into the court as far as why custody should be one way or another. Again, we can have all these experts. We can have school progress reports, witnesses, coaches. It is literally unlimited as long as it's relevant or it's somebody that's observed parents and children, or how this parenting schedule has played out and how the child seems to be reacting to it. Probably can be brought in.
Yeah. In that sort of vein, and like things that can be brought in. One of the things I was always told, I was counseled by my best friend, because he went through this and he was told this. He documented nearly everything via journals. He would just write and write and write. Came back late to pick up or late for drop off or whatever. He documented everything. Is that something that I don't know how California works, maybe it's different, but is that something that you recommend, documenting?
Absolutely. Yeah. You cannot keep track of things enough, quite frankly, because it will help you, especially if you have a reasonable belief that the other side might try to, use something against you. Document everything. Photographs, endless photographs, quite frankly, everything documented. It just needs to become such a routine for people to almost where they don't even think about it. Luckily, with technology the way it is, most people can just write notes in their phone.
Yeah. Is that admissible? Like what is it? Because I've heard various things. And again, I know states are different. I've heard text message aren't as admissible, whatever fuck that means. Emails are better. Is there in California a difference between the communication and what's admissible and what's not?
No, either are admissible as long as the person who's seeking to admit it, of course, has personal knowledge of that text. Did you receive it? What is it? When was it sent? If you can authenticate it, it's probably admissible. Meaning, was that a text you received? When did you receive it? As long as you identify it and can meet all the evidentiary requirements, I received it, I have personal knowledge, it's admissible. Now, what I would say it's easier with emails is simply because they're easier to timestamp verify, but that alone does not, detract from a text message. You can still, of course, pull it to the right and see date and time and screenshot that as well.
Okay. Well, Joseph, I could probably do this all day long because I think there's so many questions here. I think even though you're licensed in California, I think in some ways, I think that's the ideal person to talk to, because it seems to be so bad out there that it could pale in comparison to, or some of these other places could pale in comparison and be easier to sort of see the worst of the worst. But I want to thank you for doing this. You're clearly a wealth of knowledge. I appreciate it. I'm going to ask you one final question, and then we're going to find out how to best get in touch with you if anyone wants to reach out to you and potentially hire you. But the last question that I ask everybody is, what words of wisdom would you impart to a man who has just started his divorce process?
I would say probably two things in particular. Is number one, don't start it with a loser's mentality. Don't assume you are going to get screwed every step of the way. But to that same end, be proactive and don't sit around and wait. And that is something that is extremely common in men. There's a reason why over 70% of divorces are initiated by the wife. Does being the petitioner or respondent alone matter? No, but it typically does matter to the degree that the petitioner, the person who filed it, is much better prepared and already has their ducks in a row ready to go versus, like I said, to a lot of men out there that sit around and say, well, I'll just put this off a little longer.
Yeah,
because
I think
the longer you wait, the more time you give the other person to prepare, which just again puts a guy in a less advantageous position even further.
Yeah, I think men, unfortunately, we have a tendency to avoid things we don't want to deal with. And maybe that's a human thing, but I know I hear a lot of it. I went through it myself. So again, thank you. How can people find you, Joseph, and your socials and all that kind of good stuff?
Absolutely. My socials, I am on Instagram. It is joseph.willmore. My website, willmorelawfirm.com. I believe it'll be dropped down there anyway, so all that information will be there.
Awesome. Joseph, thank you so very much for doing this. I appreciate it. I hope we can do it again sometime.
Absolutely. Thank you for having me.
Thank you so much for watching and or listening. Thank you to Nick Coyle and Lifer for allowing me to use their song, Born Again, which you're hearing now and at the intro to the podcast. Thank you to Justin Dulahanty and all of my brothers at the Alpha Code. Please visit the website risingphoenixpodcast.com to connect with me and other like-minded men who are looking to thrive and grow after their divorce. And remember to surround yourself with people who add value to your life, who challenge you to be greater than you were yesterday, who sprinkle magic into your existence like you do to theirs. Life is not meant to be done alone. Find your tribe. Take care.